The court is ready to hear argument in two consolidated cases, 20-0005, the Diocese of Lubbock against Guerrero from Lubbock County and the 7th Court of Appeals District, consolidated with 2127 in re the Diocese of Lubbock, here on petition for writ of mandamus, also from Lubbock County and the 7th Court of Appeals District.
May it please the court, Mr. Hahn will present argument for petitioner. Ms. Klusman will present argument for the amicus. Mr. Hahn will open with the first 10 minutes and will present the rebuttal.
Mr. Chief Justice, and may it please the court. The case before you today is in the First Amendment's heartland. The First Amendment protects a church's decision to reform its practices on clergy sexual abuse, to correspondingly discipline its clergy, and then to explain those developments to the flock. When faced with claims based on church decisions, civil courts routinely dismiss them for lack of jurisdiction. My first and fundamental point today is that Westbrook and the First Amendment require the same result here. My second point is that nothing about this case changes that result. Not how the church communicated, not the so-called neutral principles doctrine, not the anti-SLAPP statute, which the court need not even address. If anything, the Catholic Church is to be commended for committing itself to transparency and accountability on clergy sexual abuse, not sued for it. The Court of Appeals should be reversed and the case dismissed for lack of jurisdiction. As I explained, Your Honors, my first and fundamental point is that Westbrook and the First Amendment require a jurisdictional dismissal. That's because Westbrook embodies two prohibitions that follow from the First Amendment's religious autonomy guarantee. Civil courts cannot adjudicate cases that either require the resolution of a religious question or impede good faith church governance. Yet adjudicating Deacon Guerrero's claims require both. A civil court would have to second guess the church's internal decision to apply Catholic canon law to Guerrero's conduct. It would then upend—
Mr. Hahn, excuse me, but we of course have to look at how this could affect other decisions, other cases. And so if you were to prevail, let's say if a church were to publish a list of people within the church who either had, there were credible allegations that they had, say, declared bankruptcy, or that they had committed some type of improper business practice, or that they'd committed illegal acts. And within that list were some innocent people. Are you saying that those people who had been included in that list, even though they were completely innocent, would have no recourse?
No, Your Honor, our rule does not sweep so broadly that, as Westbrook itself explained, all of these cases require a careful review and a detailed analysis. And some of the limitations on the rule we're talking about today are, one, the fact that there is a good faith application of church governance here.
Excuse me, where would be the line between those cases and a situation? What would be the distinction between the situation we have here and the publication of a list of people who had done X, let's say committed criminal acts, or let's say allegedly declared bankruptcy?
So for one matter, Justice Lerman, it doesn't sound like there might be a religious question at issue. For another matter, it's not entirely clear that there's a matter of internal church governance that might be infringed upon if jurisdiction over the case was taken.
How? Tell me how exactly. What's the difference between those two situations?
Well, if there was a matter of religious questioning or internal church governance, that I didn't perceive that in your hypothetical, but if there was, that might be different. You also mentioned members. The fact that this is what Westbrook and other cases have called the lifeblood relationship of the church-clergy relationship, Deacon Guerrero's ordained clergy in the Catholic Church, that also is an important factor.
So is that a distinction whether or not it's somebody who's employed by the church as opposed to a church goer?
I think you can have a closer case when it comes to a member, although the cases don't point necessarily in the same direction on that, frankly. Watson versus Jones, which is the landmark Supreme Court case in this area, talks about membership and voluntary association with the church, meaning submission to its rules. Penley and Westbrook, of course, was not clergy, but nevertheless, the religious autonomy doctrine barred the professional negligence claim in this court. At the same time, as I said, clergy are often referred to as having the lifeblood relationship. And here, when you have a good faith application of church governance as to its clergy, and the communication is about that good faith application of church governance, the jurisdictional prohibition following from the First Amendment has to apply. And Deacon Guerrero squarely puts both the religious question issue and the internal church governance issue as a part of his claims. He has done this since the beginning of his case. And so for all of those reasons, Westbrook and the First Amendment require jurisdictional dismissal.
Mr. Hahn,
Go ahead.
thank you. Would there be, so you began your argument with the phrase explaining to the flock, which I agree with you. Churches do that routinely on any number of matters of governance and doctrine and all sorts of things. But when the church undertakes an additional step, which is to issue a press release, if it covers the same matters, then the doctrine applies. What if it covered additional matters, the press release? So I'm trying to see if there's any place where a church could act in a way that would make the doctrine inapplicable.
Justice Guzman, as we say in our briefing, it's not that the scope of publication is entirely irrelevant. It's just not what the Court of Appeals called the pivotal nuance or a dispositive factor. It can be an indication, but the core jurisdictional questions are those set forth in Westbrook. Here, you have a press release that all it did was direct the flock to the website. And we know that that's true because it contained a link to the website, and it essentially repeated verbatim Bishop Kerber's letter to the flock accompanying the list, which makes the purpose of the list release clear, which is to restore confidence, as he says, among the ranks of the faithful, that the church's administration is serious about clergy sexual abuse. Moreover,
was it aimed at more than the flock, though? I guess that's, and if it were, does that matter?
Well, as the Fifth Circuit explained in the Whole Women's Health case, religious autonomy is not stripped from religious organizations simply because they speak in public on matters affecting their religious exercise and moral witness. And here, the Catholic Church is trying to reach out to its members to restore lost trust. And speaking publicly is a part of restoring lost trust.
Mr. Hahn, I'm also trying to understand the scope of your proposed rule. If we had a religious group that viewed thinking about a sexual relationship with somebody you're not married to as equivalent to rape, for example, and a parishioner confessed that he or she had such thoughts, and so the tenets of the group then required that be publicized both to members and non-members, and a defamation suit was filed, and the plaintiff didn't dispute that he or she had these thoughts and that it was properly determined under the church's religious teachings that was equivalent to rape, and so they published that this person was a rapist without defining that term as it's understood under that church's religious doctrine. What result in that case? Would ecclesiastical abstention apply?
Justice Busby, I know it sounds like that Westbrook might have more of a limitation there because Westbrook provides a potential exception for intentional torts involving like a battery or an assault if the publication were allowed to go forward. So you can think about the potential intentional tortious harm that could come from having a publication proceed and not adjudicating that. But here, we're very far from that, where we have a good faith application of internal church governance that investigated something and produced a conclusion about the clergy and is informing the flock so to restore lost trust in the church. That's at the heart.
Couldn't you have a defamation case that doesn't challenge the church's adjudication that this is a minor? And I understand that you're arguing that Deacon Guerrero does challenge the conclusion that there was a credible allegation with a minor. But if he didn't in this case, if this was just saying, I'm taking at face value that this, that you have properly adjudicated that, and the only thing I'm complaining about is that you're, putting out there that it was with a minor, and people don't know what that means in canon law terms, then, if it's, would that be a different case in your view?
Not in this case, Justice Busby, because he doesn't just challenge the definition. He also puts the entire church governance process on these issues at stake, which Westbrook explains is an independent constitutional protection under religious autonomy. It's not just resolving a theological issue. If this case were adjudicated, civil courts would be putting themselves in the position of the bishop to decide church discipline and how you announce it. They would make the diocesan review board's conclusions confidential, and they would encourage clergy forum shopping. I see my time has expired. If there are no further questions, I yield the balance of my time for rebuttal.
Any other questions? Thank you, Mr. Hahn.
Thank
We'll
you.
hear from the state.
Thank you. May it please the court. The church autonomy doctrine bars the claims against the diocese in this case, and that's consistent with precedent from this court as well as the United States Supreme Court. I do want to follow up a little bit on this line drawing question that I think is going to be of significant concern to the court in this case. And I would urge the court to follow the lead of the Supreme Court in the Hosanna-Tabor case, where it said, we're not going to describe, excuse me, everyone who's going to be a minister under this ministerial exception, but we're going to set forward some principles that can be followed in future cases. And we'll just refine those as those cases come up, because of course in the First Amendment, there's going to be so many hypotheticals, so many nuances. We're not going to resolve all of them once for all time in this case. So I think the court can look at 5 different things.
Excuse me, Ms. Cleveland, may I ask you? So granted, in this situation, what the church was trying to do was very commendable, and that's certainly part of their ecclesiastical decision-making. But that's not the problem. The problem is when a person's name was published within the list that was actually innocent and was not part of the group that the church was trying to cleanse itself of. That's the issue. And so how is the inclusion of someone like that part of the ecclesiastical decision-making, and where would that line be drawn between a completely innocent person and someone in this situation, in this case?
Sure. Well, and I think the issue of whether or not Mr. Guerrero should have been included on this list, or anyone on a given list, that is going to be an internal church decision, a decision that the church leaders are going to make based on the facts that are presented to them and their understanding of law and doctrine.
And so if an innocent person is included, they have no recourse?
That's possible, Your Honor. There are a couple of things that I think they could have to try and get out of the church autonomy doctrine. I think if we look at the fact that it was a church authority that made the decision about a church leader, they made it in good faith. It was in accordance with church law and doctrine, and it didn't involve physical harm or some sort of public safety issue, then those decisions are as a whole going to be protected. There is room for churches to make errors under this doctrine, similar to sovereign immunity. It doesn't mean that the government can't make an error, it just can't, deliberately violate constitutional rights. And so under the church autonomy doctrine, similarly, there may be some errors, and that person may have to resort to non-judicial means to clear their name. But the church autonomy doctrine is going to protect those internal decisions. I would like to talk a little bit about the neutral principles doctrine. As this court explained in Westbrook, that's an exception to the church autonomy doctrine because the courts normally don't become involved in these internal church disputes. But the neutral principles doctrine exists in the property context because someone has to own the property. You can't have two people fighting over who owns the same piece of property. The courts do have to resolve that. But this case is different. This isn't a property dispute. And so the neutral principles doctrine would not apply here, as the Seventh Court erroneously said it did. We can see that also with
Ms. Klusman, that this circuit was wrong to apply that doctrine outside the property context?
I believe the Fifth Circuit didn't necessarily say that it applied. It just said it was too early to make that decision. Obviously, that was a very closely disputed case. I assume you're referring to the McRaney case. That was 9-8 denial of en banc. And so the state did support the church in that case in an amicus brief. And so we did disagree with the panel's decision that it was too early to decide whether the church autonomy doctrine applied. But here, it's not too early. The court can decide. We have the facts. We have what the church did. Mr. Guerrero, as I understand, has the evidence that was in front of the church. So if he has claims about lack of good faith or anything of that nature, he has the information to make that argument to the court today. And so,
what makes this one more difficult, it seems to me, is the fact that the diocese chose to issue press releases and put the information on a public website. And I'm thinking of the cases where, like in the Protestant realm, a church chooses to disfellowship somebody and gets up in the pulpit on a Sunday morning and says this person's been disfellowshipped. And the courts have mostly said, well, that's a matter of church doctrine and the abstention doctrine has to apply. But if a church in the Protestant realm chooses to disfellowship somebody and gets up in the pulpit and says it, but then starts issuing press releases and spreading the word of that decision out to the general public, are there cases that say that the abstention doctrine continues to apply in that context?
I see my time has expired, but I will keep it short. There are a few cases, Your Honor. I would point the court to footnote 17 in the diocese's brief. It lists several cases involving the publication of information that was, I guess, allegedly believed to be defamatory, but to publish it to non-members. And then I would just add that reflects sort of a cramped view of the First Amendment, if that were going to be the rule, because people who privately practice their faith don't need much First Amendment protection. It's when it enters the realm of the public that we need that protection. And so I would urge the courts, because this was in accordance with the charter, to be transparent about these issues, that it was still a matter of a church acting in good faith in accordance with its doctrine.
Any other questions? Thank you, Ms. Klusman. We'll hear from the respondent.
May it please the court, Mr. Olguin and Mr. Price will present argument for respondent. Mr. Price will open with the first 10 minutes.
May it please the court. We just had a lot of discussion about the internal church decision and their decision-making process, but the reality and the irony in this case is the church went outside the church for the decision makers. If you look at the record, they brought in, the list itself says that they brought in outside law enforcement, and the church lawyer went out and hired a private lawyer to review the clergy files to make the determine of what is a credible allegation. So my point there is that not only was the publication made outside the confines of the church, but the decision-making process involved outsiders. If you look at in our record, the combined record, page 137, it references it's the interview where Justice Corver says, we're giving a whole lot more credence to civil law and societal norms. And he also says there, we're bringing in objective people. He's talking about the law enforcement and the private citizens.
But,
So,
Mr. Price, is it unusual to bring in professionals? For example, if there were an allegation and the church wanted to consult with a child psychiatrist, for example, to talk with the child to decide how they would proceed internally to discipline or not, is that fact in and of itself dispositive, or why is it so significant in your view? Because it seems law enforcement might have been brought in for the same reason.
Your Honor, I don't think it's dispositive. I think it's a factor or a pivotal nuance as the Seventh Court of Appeals set out. But in this case, I think they're saying, the church is saying that this was internal doctrine or internal law. What's telling is that they didn't say we brought in a church lawyer or a biblical scholar. We brought in these outsiders to determine a credible allegation. So you have that issue. And then also we have two defamatory actions. We have the specific statement by Marty Martin that he gave in an on-camera interview that says Jesus Guerrero and everybody on the list either admitted it, they were convicted in a court of law, or the church has witnesses, they have testimony from witnesses who observed the abuse. Those things, those are all concrete facts. Those I'm kind of getting away from the question, but I want to go to Tilton versus Marshall. In that case, it was a fraud case that this court allowed the fraud claims to go through because they were concrete facts that were subject to the falsity of which could be tested. That's what we have there, and that's particularly made clear in Marty Martin's statement that those are all concrete acts that can be proven. The First Amendment has never immunized all allegations, all tortious causes of action under the guise of the First Amendment, and the church here is seeking.
Mr. Price, how did Mr. Guerrero get placed on this list?
The church placed him on that list.
I know, but the list was supposed to be comprised of people who had credible allegations of abuse of a minor. Right. And my understanding of the record is that there were no such credible allegations against him. And so why was he included in a list of which he was not a member? Your
Honor, more than a decade ago, there was an incident between Mr. Guerrero and an adult woman, a 41-year-old.
But that's my question. His incident was with someone who was 40 years old, not a child.
That is correct.
And so why was he included in a list that was published to be a list that included people who had been accused credibly of abusing a child?
Well, I mean, the church would say that because they determined he was that the other person involved with the incident that happened 10 years ago was a vulnerable adult. They believe she was a vulnerable adult, and so they included him in the basket of cases involving children.
So it was an intentional act that you're saying that it was intentional because of her challenged capacity?
Yeah, yes, Your Honor. Excuse me. I don't believe that it was an accident. The church looked at his case and said a vulnerable and published it because of the incident that happened with the adult.
Mr. Price, does it make a difference that there's a secular analog that the penal code provides for an exception to consent when an assault or an abuse happens by the member of a clergy and the victim is incapable of consenting due to the clergy member exploiting the victim's emotional dependency?
If I understand your question correct, Justice Bland, I think that might matter if they had accused him of abusing a vulnerable adult, but we're saying he abused a child. That the revised list mentions vulnerable adult, what didn't come until months later and after we'd filed the lawsuit. At that point, the bell had already been rung. So what they accused him of and what was the reason for this lawsuit was the accusation that he sexually abused children.
And how do you distinguish Hosanna Tabor and Our Lady of Guadalupe, where there were colorable claims of discrimination, illegal discrimination in the employment context? And the U.S. Supreme Court said, despite these discriminatory acts, the First Amendment and free exercise trumps in the management of a clergy member.
Your Honor, without question, and under the employment context and in the discussions of a minister or a teacher, Hosanna Tabor and Lady Guadalupe both apply basically the ministerial exception, which is immunity. If it has anything to do with the teaching or leading of the flock, the Supreme Court says that is hands off. if it's any type of an employment decision. And Patton, the Texas court case, is talking about the ministerial exception, and that was before Hosanna Taylor, but that's what they're talking there. If it has anything to do with preaching or teaching or employment decision, it's ministerial exception, and religious autonomy applies. But the church in this case, in the Seventh Court of Appeals brief, they admit, they on page 35 of the record, which it's GAW 35, they admit this is not an employment issue, and the ministerial exception from Hosanna Tabor is irrelevant. And I agree, it's not an employment decision.
Does your case boil down to the church could not use the word minor in a special way without explaining it?
I don't think we can take it that far, Your Honor. It's not just about that. If they were intending to use church law in their definition, they should have told the reader that. You've got to look at all the factors. These cases are cloudy, they're murky. You got to look at all the factors. The fact that they went outside the confines and sought out a secular audience, and then are trying.
But if he had really sexually abused someone under the age of 18, the church could have said that. You don't object to that?
I don't object to that.
Well, in other words, how would the analysis differ, and would you even have a claim if instead of using the word minor as to this plaintiff, the church had said minor or vulnerable adult from the very beginning?
Well, Your Honor, that's what they did or attempted to do in their clarification. And then
I know, but you're saying the bell had already been rung by then, and that. But in terms of the abstention doctrine, how would it change the analysis if they had used the word vulnerable adult from the very beginning in all of their public communications?
I don't think only using the word vulnerable adult gets them there, but if they say under church law, we consider a minor the same as a vulnerable adult. I think it's a lot closer call, and we may not have a case had they spelled that out. But for Marty Martin's interview where he said we admitted it, we were convicted of it, or they have witnesses that observed the abuse. I mean, those are still false, whether they say vulnerable or adult or not, and we would hope to be able to prove that at trial, and we think we will. But
that would just be a fact issue as to truth of the alleged defamatory statement. I'm talking about the abstention doctrine. How would that affect the analysis of whether the court has jurisdiction to hear the case at all?
Well, I don't think simply including the words vulnerable adult makes the abstention doctrine apply. You still have to look at the underlying issue. What are we talking about here? Secular sexual abuse of a minor or vulnerable adult. Sexual abuse is illegal in all 50 states. It's a crime in all 50 states. So it would have to be something more than just using the word vulnerable adult.
Any other questions?
I have one, Chief.
Yes.
What is your response to their argument that if the list had included somebody that was completely innocent, that would have been okay?
Well, I would say that's not okay. I think we're completely innocent. We expect
but let's just look at someone else.
Okay.
Let's say if it's clearly person X who absolutely the record shows is completely innocent and everyone agrees that's not an issue.
Well, I think they've defamed that person as well. I don't. The religious autonomy doesn't give them the immunity to falsely accuse someone of a secular crime. I mean, that's the point. It's a secular issue of sexual abuse.
But I guess my question is, their argument a moment ago was that is a church decision of whom to include in that list, period.
That I don't dispute that they made that decision, but I dispute that that's a religious decision and involves a secular topic. They brought in outsiders to help them assemble their list, and then they published it outside. So I think looking at the factors, the fact that they made this internal decision doesn't make it a religious decision. the outsiders they use, the outside the publication, and the topic. Sexual abuse by itself is a secular crime.
Any other questions? Thank you, Mr. Price. We'll hear from Mr. Ogan.
Good morning.
Good morning.
May it please the court. I'd like to devote some of my time to why the Seventh Court of Appeals got the decision right in the lower court. The diocese is critical of the Seventh Court of Appeals because they say that they created a hard and fast rule that all publications that occur outside the confines of the church would break church autonomy. When really, in reality, what the court said is that when discussing the outside the confines analysis, the Seventh Court of Appeals said that if a publication is made to the general public, that is not to say that such a publication alone may not always be enough. They leave room for other nuances to be considered. But communications to the general public, as the Iowa Supreme Court said in Clivenstein, weakens the ecclesiastical shield. Now, the court used the proper nuance analysis, and this is the same analysis that courts have used throughout American jurisprudence. In Bryce, Hubbard, Patton, Turner, even in Westbrook, that now they don't use the word nuances, but they all discuss the context and the subtle factual distinctions in each case, namely the who, the what, the when, the where, and the purpose of the communication. Those things are always analyzed. Now,
is it a communication, Mr. Olguin, to the general public and not the flock if the communication is intended to cover members of the flock that don't come to church anymore because they're disillusioned, or to cover members of the flock that for any other reason would not see the church's Sunday memo? I can see where a church would make a decision to disseminate more broadly to capture members of the flock that are outside of the church for whatever reason.
well, they might be making that not to members that are outside the in the world and not in church, but you got to consider the topic that was done in this case. The topic in this case was a secular crime, a crime against child abuse. So if you look at the record, and the record bears out that what happened in this case was the church was concerned with interjecting themselves into the conversation with society at large regarding the broader problem of sexual abuse. As the Court of Appeals, Seventh Court of Appeals properly noted, that what they were discussing in the case was the broader issue of child sexual abuse, how society has ignored it. They induce society to do something about it, and then they talk about joining the conversation. Yeah, so I find this case is unique. It's factually unique from any of the cases that I've been able to find. In that, number one, the diocese in this case voluntarily interjected themselves into the conversation. Not only did they do that, but they enlisted the help of outsiders, people who didn't have a training in canon law or theology, or they didn't hire any priest. They hired these people to determine what a credible allegation was so they can communicate it to the public. So what they're talking about here is not whether or not there's a real presence of Jesus Christ in the Eucharist and the church's tenets on that. What they're talking about is the allegation of a serious crime in our society, probably one of the most heinous crimes that a person could be accused of. Now,
Counsel, I wonder whether the Seventh Court and your position perhaps gets this sort of backwards in a way, which is that this idea that the internal church decisions or an employment decision, or if they'd kept it just to the membership, if that would be protected, but because they issued a public statement that is not protected, it seems to me that might get it exactly backwards. Because if the church deems this information of sufficient importance for the propagation of its public mission and decides to release it on that basis, perhaps it's even more important that be protected by the First Amendment, and that the church's decisions about how to pursue its mission in public are even deserving of more protection, both under the free exercise of religion and the freedom of speech, than are its internal deliberations, and perhaps the First Amendment guarantees to the church that it can make those proclamations based on a religious motivation, free from concern about civil tort liability. And if it can't, then it's going to have to make decisions about what to say publicly in pursuit of its religious mission, with an eye towards how judges and juries are going to view what it said. And as I said, I wonder whether we're getting this backwards, and it's even more important to protect the church's public statements than it would be to protect its internal deliberations.
Well, I disagree I don't think we're getting it backwards from the standpoint that, considering the context of what we're talking about here, we're talking about, again, a secular crime. We're talking about, and not only that, they're allowing this to go forward, basically allows, I mean, not allowing this case to go forward, basically affords the church in this case, the diocese in this case, complete immunity to say whatever they want to say, even whenever they're dealing with innocent people. Basically, what the diocese wants to do is they want to play a game, make the rules, and never be called on a foul. So I disagree that.
Well, I think what the diocese is saying is that there's a special definition within canon law of what minor means, and that there is a credible allegation here that within that definition that Mr. Guerrero did engage in that conduct with a minor under that definition. And so I guess I want to be sure I understand what you're challenging, because I think part of what you're challenging is that determination, right? That there is credible information that he engaged in sexual misconduct with a minor as defined under canon law, right?
Correct. That is correct.
So why doesn't that get into the heart of attacking the church's internal decision-making about a matter of its own law?
Because it also touches on a secular issue of criminal law. They're basically accusing Guerrero of a criminal offense. Now, they have a different definition of minor. That's of no import, because Texas defamation law says that what's important is what the ordinary person of reasonable intelligence understands the words that were spoken to mean, and considering the context of how it was made. So in this particular case, you have press releases talking about child and children and using those interchangeably. And the diocese says they never uttered the words child or children, but they did. If you look at the record, they're releasing this list to protect children. So our claim is Mr. Guerrero gets credibly accused by the church of sexual abuse against a minor. That's a criminal offense, and that's a terrible crime to be accused of, especially when it's false. So I'm not sure that I answered the question, but I'm trying to do the best that I can. I think that the difference in this case is that just because a church says, by that definition, they can decide whatever they want to decide is a matter of church governance and church polity, and they can do whatever they want just by speaking the words. And they would enjoy complete immunity.
Well, what's the problem with them enjoying complete immunity? I mean, we have a First Amendment, and one of the consequences of guaranteeing people liberty is that the outcome of the exercise of that liberty will not always be fair to everyone. I mean, we have competing values here. We have the church's freedom to disseminate its message and to speak publicly in its religious mission. We have competing with that, we have the fairness to Mr. Guerrero. And those are competing values that are at stake here. And they're both important values.
Well, it's not
just, why doesn't the Constitution answer the question of which of those values has to prevail in this situation? And it speaks to freedom of religion. It doesn't speak to general notions of fairness to litigants prevailing over absolute religious freedom that the church enjoys under the Constitution.
Well, because the tenet, or the thing that we're talking about here again, is a secular crime. It's got nothing to do with religious tenets. It's got everything to do with whether or not he committed a criminal offense. That's the difference in this case. This case, they're not talking about their religious tenets and what they believe it to be. They don't have a monopoly on that. Churches have never enjoyed immunity. Complete immunity.
Do you think they're being disingenuous when they say that their motivation for releasing this information is religious?
I think they're being disingenuous because if you consider the record and what was said, what Bishop Corber says is We have long held, the Catholic Church has long felt that they've been above civil law. And in doing that, they're not giving deference to the ecclesiastical decision makers, they're giving deference to society. They're speaking in society to society. So that's the major difference.
That's what churches do. They speak in society to society as they see fit. And that's what the Constitution allows them to do.
Okay, I see my time is up.
Any other questions? Thank you, Mr. Olgan.
Thank you, Judge.
Mr. Hahn, I believe you have 5 minutes.
Thank you, Mr. Chief Justice, and may it please the court. Just a few brief points in rebuttal. First, this case is about communicating to the flock about clergy. That's at the heartland. Well, Justice Bland mentioned Hosanna Tabor and Our Lady of Guadalupe, identifying the fact that there is not a complete immunity from all civil law in all cases for all times. When you're talking about a church communication about its clergy and their standing under disciplinary and other administrative status, that is heartland. That is the core of the religious autonomy protection, and it has to be protected.
Is Mr. Hahn, is there, they made a statement, I think, where they sought to join community efforts to protect children. That's also rooted in biblical, Isaiah 54:13, great shall be the peace of your children. So I don't have a real problem with that. Are there any lines to be drawn there?
Justice Guzman, as you pointed out in mentioning disillusioned members, that in order to reach the diocese 136,000 members spread across 25 West Texas counties and over 60 parishes, it uses ordinarily its website. That's how it draws members to what's going on in the church. And there could very well be, as you said, disillusioned members over this very issue. And so it's all the more important for the church to further its religious mission by speaking in this transparent and accountable way, which is what the church committed itself to. An alternative rule where a civil court is line editing and micromanaging a church's communication will necessarily raise ecclesiastical questions over how a church understands its membership, its organizational structure, and its resources. Those issues are ecclesiastical, and for all of the difficult balancing, when those kinds of questions are at issue, as Hosanna Tabor said, the First Amendment struck the balance for us, and that's why this case must be dismissed for lack of jurisdiction.
Mr. Hahn, several Jewish leaders filed an amicus that said, look, we communicate to the public when a business hasn't complied with requirements of kosher preparation of food under Jewish law, according to Jewish law. And we could potentially be sued for business disparagement if a business lost business because of that. But your opposing counsel is drawing a distinction and saying whether you comply with Jewish law is a religious determination. But here there was a question about complying with secular criminal law, and that ought to be looked at differently. Why should that not be looked at differently?
Justice Bland, I think my friend's presentation on the other side, where they admitted, among other things, that they were challenging internal church determinations, confirm what Westbrook said, which is that trying to limit the religious autonomy protection only to whether you have to resolve a theological question to resolve the dispute goes to only one area of constitutional concern and ignores another. You have to consider the chilling effect on church governance. If you were to take jurisdiction over this case, civil courts would be second-guessing a bishop's determination about how to discipline clergy and announce that discipline. The diocesan review board's work, which is supposed to be confidential under the charter, will now be subjected to civil discovery requests, and clergy will be able to forum shop between the ecclesiastical forum to address supposedly unsubstantiated allegations of reputational harm, or bring million-dollar tort actions instead. Wading into these areas violates a good faith application of church governance, and that's why these claims must be dismissed for lack of jurisdiction.
Any other questions? Thank you, Mr. Hahn.
Thank you.
Case is submitted, and the clerk will adjourn the court.
Oh yay, oh yay, oh yay. The Honorable, the Supreme Court of Texas now stands adjourned.